Hello, my name is Andrew Sexton,
And I'm Matthew Sexton.
and we decided to do our project on the agricultural employees under the Fair Labor Standards Act. We are fourth generational farmers at Sexton Christmas Tree Farms. Our farm was established by our great grandparents in 1960. The reason we decided to do this topic was in 2004, our family was faced by a lawsuit that to decide whether we are H2A or H2B, which we will later discuss in this PowerPoint. Starting out, we're going to look at the Free Labor Standards Act, or the FLSA. This establishes the minimum wage, overtime pay, record keeping, and youth employment standards. We all know that the current minimum wage is $7.25, and that you get time and a half over your normal 40-hour work week. This affects all employees in the private sector as well as any governmental job. Certain growers of the Christmas trees in North Carolina found, because the seasonal nature of the industry, they needed a substantial number of workers at certain periods during the year, but required fewer workers at other times. To fill their manpower requirements, the North Carolina Growers Association arranged for the hiring of temporary, unskilled, legal alien agricultural workers under the H2A program. Under the H2A program, the workers were classified as agricultural, and some might argue ought to be exempt from the basis of overtime pay procedures, which brings us to the difference between H2A and H2B. H2A is seasonal work, and you are exempt from overtime pay, but from this exemption, you have an elevated rate of pay of $9.87 in the state of North Carolina. H2B is every other work that does not include agricultural, such as landscaping or constructional work. Also, the H2B has to follow the standards set forth by the FLSA.
When the H2A workers were initially employed in the Christmas tree industry in 1993, the Department of Labor advised the employers that such workers would be classified as non-agricultural and thus subjective to overtime pay protection under the FLSA. From 1993 to 1995, the growers complied. In 1996, as a result of the conflicts of interpretation, the growers ceased to pay overtime rates and ultimately were taken to court by the Department of Labor. The case brought against North Carolina Growers Association that the Christmas tree growers were now considered to be both H2A and H2B, requiring them to pay an elevated rate of pay along with overtime. They were H2A by the agricultural aspect of growing trees, and they were H2B by being considered in the timbering industry. The argument brought forth by the North Carolina Growers Association was that a business cannot be both H2A and H2B, that it must be considered in only one of the two categories. In the 107th Congress, Representative Ballinger introduced legislation to clarify the language of the FLSA to ensure that Christmas tree farming is agriculture under the Act. Workers employed in the industry would not need to be paid overtime rates for hours worked in excess of 40 per week, referred to the Subcommittee on Workforce Protections. The bill died at the close of the 107th Congress. Representative Ballinger has reintroduced the legislation in the 108th Congress, now seeking both to clarify the terms of the FLSA and in effect to overturn the decision of the District Court. Again, the bill died at the close of the 108th Congress. This then went to appellate court, which concluded that the Christmas tree industry was solely H2A. This held that the cultivation, growing, harvesting of Christmas trees is agriculture, as defined in the Fair Labor Standards Act, and therefore the employees at issue were exempt from the overtime pay provisions of the Act. The final verdict was that the Christmas tree industry was considered H-2A.
Once again, this is Andrew Sexton.
And I'm Matthew Sexton, and we just wanted to thank you for watching our video, and we hope you enjoyed it. And feel free to contact us at our emails. They're at the bottom right, and you can leave comments, or you can just tell us any questions or anything. Thanks for your time.